Hello everybody, I'm Spencer Mazyck, and this is the Bloomberg Law Podcast. On October 3rd, the Supreme Court of the United States will commence its next term. And joining us to discuss several of the business cases that the court will review is Tom Goldstein. He's a partner at Goldstein Russell and is the founder of SCOTUSblog, a website that tracks the Supreme Court. Tom has also argued over 20 cases before the court. Welcome, Tom, and thank you for joining us today.
Thanks so much for having me.
So before we take a look at the upcoming term, let's take a look back at recent terms. And tell me, has the Supreme Court become increasingly focused on business issues?
Yes, I think the numbers show you that the court has taken more and more business cases. You could attribute it just to a general sensitivity by the justices or the fact that John Roberts is now the Chief Justice and used to represent the business community. And not that he has a pro-business bias, but that he really is able to explain to other members of the court why it is important for them to resolve some of the uncertainties in the law that affect business.
Well, now, there are some who say that this Supreme Court, the Roberts Court, is the most pro-biased of any since the 1930s. So are you saying that he's not at all, or the court is not pro-business?
Yeah, I think it overstates things to say that the court is pro-business. I think the court believes there's too much litigation, too much regulation through the courts, or at least the more conservative members of the court. And that means businesses who tend to be defendants win kind of a disproportionate number of cases. But it's not because they are businesses as such. The famous Citizens United case about campaign finance benefits unions as much as it does business. And if you look at the civil rights cases from last term, individual plaintiffs beat businesses repeatedly. So I think it probably is a misstatement to call it bias. The court is trying to fix what it thinks are some structural problems in the law.
Well, and Justice Breyer agrees with you. In an interview with Bloomberg News, he actually said that we rejected the notion that they're pro-business and said that businesses haven't been any better today than they have been historically. They aren't any better today. So whether or not the court is pro-business, we'll leave that for others to discuss. But I think we can agree that the court is deciding more business cases that affect corporations and consumers to a greater degree. So with that, let's take a look at the upcoming term. And there's one case in particular, it's the FCC versus Fox, that I think might shake up the world of media and entertainment. What's that all about?
Well, FCC versus Fox is making its second visit this question to the Supreme Court, and that is, what are the rules that the government can put on broadcasters for their broadcast of indecency, particularly in evening hours? This is typified by kind of George Carlin's 7 Dirty Words was the original case that made its way.
1978, I think the decision came out.
Exactly right. And the court is coming back to the question of both how many restrictions can the government put on the broadcasters and how clear does it have to be in articulating those restrictions. So this is a case under the First Amendment, and that is, are the restrictions that are being applied by the FCC in its indecency rules unconstitutionally restraining free speech?
Well, and in the George Carlin case, the court actually sided with the agency there and allowed it to find the broadcast station, the radio station. So what do you think the outcome is going to be the same here?
I don't. I think the broadcasters probably have the upper hand for a variety of reasons. The court's more protective of the First Amendment, but there's also a lot more choices now than there used to be. The court's early indecency decisions really had a lot to do with the fact that if you were an American in the 1970s, 1980s, you had very limited entertainment options. You were going to turn on broadcast television. But now there's so much cable TV, parents have so many more choices. I don't think the court's going to throw up its hands, and I think the court will be divided. I don't think it's going to say the government can't do anything, but I think the broadcasters are going to get increasing freedom. The Court of Appeals here ruled for Fox, and I think the Supreme Court will probably do the same thing.
Okay, so let's switch gears a bit and move away from the First Amendment and talk about the patentability of medical diagnostic claims. Could the decision in Mayo versus Prometheus Laboratories shape or mold the landscape for the business of personalized medicine?
I think it has significant consequences. The Supreme Court, in a case called Bilski, had taken up the question of what is a business method patent. What is a method of doing something that you can patent and therefore get a long-term exclusive right to? The Prometheus case...
In Bilski, for the record, it dealt with abstract ideas, correct?
That's right, and ultimately that's what the Supreme Court said, is that the claim patent in that case for a method of hedging commodity transactions was just an idea. It wasn't an actual invention. So the Supreme Court articulated a certain test that was one of several tests and factors that could be applied. And now we get into kind of a second generation case where the Supreme Court is now confronting how to apply the test about these kinds of methods. And this is a method for determining drug reactions. And that's what the Mayo Clinic is saying can't be patented because it's what doctors do all the time. if the Supreme Court allows a patent to be issued here, then a lot of these sorts of tests that you ordinarily might think of things as doctors or nurses, medical professionals doing, could end up being patented and people having exclusive rights to.
So what do you think the outcome is going to be here? Will it suffer the same fate as Bilski?
Well, in Bilski, they invalidated the patent, and I would have to say that there's a good chance of that happening here, too. The Supreme Court wasn't quite as hostile to business method patents in Bilski as we thought, but it came really within a hair's breadth of saying you couldn't ever have them. So there are several justices on the Supreme Court that are really willing to kind of throw this baby out with the bathwater. And so I would think that the betting money would be on the Supreme Court continuing to pull back on the scope of patentable business methods, and the fact that they even took the case is one indication of that.
Yeah, because this is the second grant of cert, is it not?
Right. Well, they had decided Bilski, and they kicked this case back to the Court of Appeals, which is a pretty administrative task. But it is a second case in the sense that they had taken Bilski, and they're already stepping in and taking another one of these cases.
Okay, and so the next case, Sackett versus the EPA, it has the potential to drive a wedge, I think, between property rights activists and environmentalists. And I have to say that after reading the facts of this case, I kind of fell in love with them, but I think folks might understand why if you tell us a little bit more about it.
Sure. Well, the EPA has very broad powers to step in and issue what are known as unilateral administrative orders and other unilateral steps saying you've got to go in and clean this up right now. You've got to take some what it regards as emergency action. In truth, these emergencies sometimes aren't really emergencies, but they are a way of the EPA being able to really push people and get environmental cleanups. And under the statute, at least as the EPA applies it, you get your order from the EPA, you then go do the cleanup, and then you go to court. And the question is, in our system of law, does it really need to be the other way around? The story of the plaintiffs here is, look, we have a system of laws that says the government can't force me to do something until I have a chance to tell a judge why I shouldn't do it. The EPA story is, look, if we sit around here forever, then the pollution is really going to hurt people and it's going to be too late. And so the court's having to decide what does the law require and what does the Constitution give as rights to first be able to go to a judge.
Yeah, but aren't the plaintiffs here incredibly sympathetic? Don't they feel like the mom and pop who are getting the heavy hand of the government brought down on them? I mean, you have them building their dream home here.
Right, that's true. It is a kind of beautiful set of facts, and facts can matter. And it is striking that the Supreme Court took up this case after turning down a very similar case from GE about cleaning up the Hudson River.
Okay.
So they did take a much more sympathetic set of facts where the EPA looks considerably more heavy-handed than it did in the Hudson River case.
So what do you think the outcome is going to be here?
I think the fact that they took the case indicates some sympathy for the plaintiffs here, that the EPA can't force you to do this cleanup and say, well, you know, you can refuse to do it, but you might face enormous penalties. I think the court will be close, but that the EPA, it's far from a far shot. This a sure thing. The EPA has really exercised this power without question for a long time.
Well, I was going to say, wouldn't it weaken the EPA in some ways if that were to happen?
It depends on what exactly the rule is. If everybody has the right to go to court first, then that really will set up some hurdles that will probably be a problem for the EPA. But if the court were to say, well, look, you've really got to make a judgment here if this is really an emergency or not, or whether you're just exercising the power every day, that might be a more limited rule.
Wow. Well, in our remaining moments, we want to talk about one last case. It's a securities case. Yep. Of course, this would not be Bloomberg law if we didn't discuss securities. So it's Credit Suisse Services versus Simmonds. What's happening in this case?
This is a case about the statute of limitations. It's a plaintiff's lawsuit against CS. And the question is when you have to bring your lawsuit. Very common question, is the lawsuit brought too late? And the plaintiffs argue that the time, the 2 years that they have to bring their lawsuit, was told by the fact that the transactions, the short swing transactions that are supposed to, that underlie the case, hadn't been disclosed to the SEC. So it's both that narrow question about whether the failure to disclose something means that the plaintiffs have longer to bring their lawsuit. They say, well, we didn't know about it, so how could we have to bring the lawsuit? When it comes to a particular kind of transaction, and then just a broader question under the 1934 Securities Act, whether there should be tolling at all for a variety of circumstances. So the Supreme Court could decide either the broader or the narrower question. The issue here is for companies that want to have certainty that their liability is closed and they won't be sued and what's done is done. That's their position. The position of the plaintiffs is this is really a question of fairness. If these events hadn't been disclosed, how in the world could I have brought a lawsuit about them? and companies will just have an incentive to hide things.
Well, it'll be interesting to see which way the court decides on this. But thank you very much. We're going to leave it there. We appreciate you joining us and for your insight.
Thanks so much for having me.
That was Tom Goldstein from Goldstein Russell. For more information on this or other topics, log on now to BloombergLaw.com. Bye, everybody.